Hello everyone, I'm Dr. Kalpana. In this lecture, we will try to understand the law of trade unions and collective bargaining. The law of trade unions and collective bargaining forms the cornerstone of industrial relations, balancing power dynamics between employers and workers. Trade unions are voluntary associations protecting members' interests, while collective bargaining is process of for negotiating employment terms and resolving disputes peacefully. The right to form unions is protected under Article 19(1)(c) of Constitution of India, with the Trade Union Act 1926 providing a legal framework. In the age of economic liberalization, unions face challenges extending right to informal sector workers, gig economy participants, and contractual labor. Now, coming to the brief history of trade unions and collective bargaining in our country, origin and development traces the global and Indian trade movements, highlighting British influence on Indian labor laws. As we know, before 1947, we were under British rule, and British rule had been very, very exploitative in nature. So, globally, there were labor movements. Colonial era unionization, key phases of unionization, including the formation of All India Trade Union Congress in 1920. That is very significant. Post-independent role, unions' role in India's freedom struggle and post-independence industrial development. Collective bargaining evolution of collective bargaining for dispute resolution and industrial harmony. Key references law include Trade Unions Act 1926 and Industrial Dispute Act 1947. What is the benefit of forming trade unions? Trade unions are recognized as a legal entity. They are immune under this Act of Trade Union Act 1926, immunity from civil suits, protection in the cases of economic torts such as inducing breach of contract. Section 17 provides immunity to trade unions in such cases. Immunity from criminal conspiracy, protection under specific conditions when pursuing legitimate union objectives. Section 18 protects trade unions members from criminal conspiracy. There are landmark case interpretations under Section 1718 of Trade Union Act 1926, including Rohtas Industries versus Brish Nandan Pandey. These immunities empower unions to act collectively within lawful boundaries, ensuring their ability to advocate for members without undue legal interference. Registration and recognition of trade unions. So, registration procedure examines the process under Trade Unions Act 1926, Section 329. That's a chapter of registration process, including conditions for valid registration, minimum members, and submission of constitution and rules. Legal advantages that highlights benefits such as corporate status, immunity, and capacity to sue, to be sued. So here, what is important to understand about trade union? They are incorporated just like separate legal entity from its members. Concept of recognition explores recognition, which is not Trade Unions Act, but evolved through industrial jurisprudence, case laws, state laws like MRTU Pulp Act that is passed by Maharashtra government in 1971. Now coming to right to strike, which is a very, very significant right, which is a statutory right in nature, not a fundamental or constitutional right. Our legal framework explores right under Industrial Dispute Act 1947 from section 22 to 24, that is the bracket of the section to be kept in mind. There are several types of strike, covers legal versus illegal, justified versus unjustified, general strike, go slow strike, and bandh. Constitutional dimension right to strike is a statutory in nature, not a fundamental right. Judicial pronouncement includes Kameshwar Prasad versus State of Bihar, T.K. Rangarajan versus Government of Tamil Nadu, which are landmark judgment relating to the concept of interpretation of strikes. Unionization in informal sector. Structural barriers challenging and organizing informal workers like migrants, domestic workers, and street vendors. There is a challenge. Efforts by organizations like NGOs, Self-Employed Workers Association like SEVA, cooperatives represent these groups. Legislative reforms need for policy reform to support collective bargaining in non-traditional and unorganized sectors. Digital platforms, emerging role of digital platforms, platform unions in organizing gig workers. Now, to conclude this lecture, understanding the legal framework of trade unions and collective bargaining is vital for protecting workers' rights and ensuring industrial peace as Indian economy transforms with technological innovation and formalization of labor. The role of trade unions must be reimagined. A robust and inclusive system of collective bargaining supported by law can contribute to more equitable labor relations, democratic workplace practices, and sustainable industrial